everyone. Good morning, good afternoon, good evening. Hope you're all doing well. Not done a live stream for a few days. So I was going to do Sebastian Rogers actually today because it was 7 months yesterday that Sebastian went missing. But I'll do Sebastian tomorrow. And then I thought maybe I'll do Kohlberger because the Kohlberger's hearing. Anybody see that from yesterday? The new judge. The new judge ain't playing. I like him. I do like him. But there wasn't anything really to talk about. It was just, the judge's expectations and when they might decide to do the trial. The trial currently is set for June, but the judge wants to move it. The judge either wants to move it to May or September of next year. So there wasn't really anything to talk about. So this came up. Now, this is a case that I don't know. It's the murder of someone, a 19-year-old young man called Shawn Seesahai. And his killers are two 12-year-olds. So the youngest knife murderers ever in the UK were sentenced today. So the trial happened. This is a UK case. The trial happened and sentencing took place this morning. So for those not familiar with UK criminal justice, cameras are not allowed in UK courts and never have been. There's moves to introduce them. And some judges now will allow cameras in court for sentencing. And there's been numerous high-profile cases where judges have allowed cameras in for sentencing. And I'm assuming that, even non-high-profile cases, some judges are allowing cameras in for sentencing. It helps with, for families and things like that. Anyway, so the sentencing of the killers of Shawn Seesahai happened this morning. I started watching it on the replay. I missed it live. I was outside. So I was watching it on the replay, and then I was looking through the comments, that people leave. And I thought, I'm going to talk about this. So this is why I'm here to talk about this, because it seems that the judge has given them a criminal sentence. A criminal sentence. What I mean by that is the sentence is criminal. So I'm going to talk about it. I'm going to play the sentencing hearing. I started watching it, and maybe I watched 5 minutes of it, and I thought, no, we're gonna watch this together. So yeah, I don't think I'm going to be very happy. I really don't think I'm going to be very happy, given some of the comments that have been left. So Purple AJ has jumped in before the stream started, by the looks of things, with 10 gifted memberships. Thank you so much, Purple AJ. We've got Pam, Danny, Laurie, Petunia, Poco, Betsy's Barn, Naomi Jane, Katie, Kathy, and I think there's one more. Oh, it jumped. I think we've got one more. Let me just scroll back up. And Kimberly. Thank you so much, Purple AJ. You are an absolute superstar. So, yeah, welcome you guys. Get a month's free membership, courtesy of the wonderful Purple AJ. So, say a couple of hellos. Give people a chance to come in. I don't know how many people are now watching my channel. I got a lot of UK viewers after Jay Slater, the Jay Slater case. I got a lot of UK viewers. So I'm guessing maybe many of them have dropped off now, given that I've gone back to US cases. So it'd be interesting to see how many people have got an interest in this topic, because I don't know the case. I don't know the case at all. And it's literally just the sentence that I want to talk about. Knife crime is a massive problem here in the UK. We have a lot less gun crime than over in the US, because guns are, I mean, look, if you want a gun, you can get a gun, even a handgun. You know, that the rules on guns, like air rifles, are fine. Shotguns are fine with a license. There's a bunch of guns that are fine with a license. Getting a license takes a little bit of time, but most handguns are banned. They've been banned for a long time. Like you just can't use them. However, there is a black market for handguns, and if you really want one, you can get one, but not legally. So there's a lot less gun crime. There is some, but a lot less than in the US. But knife crime, the use of bladed weapons is insane. Insane. All different kinds of bladed weapons. And in this case, two 12-year-olds murdered Shawn Seesahai with a machete. Decided to go walk about with a machete. All right, so that's where we're at. That's where we're at. So before I play the sentencing, I just want to read this article. It's only short. It's published in The Guardian. Just to give a little bit of context, family of murdered Shawn Seesahai say they are haunted by thoughts of his last moments. So, teenager, 19 years old, this is Shawn here, killed by two boys, then aged 12, with a machete in Wolverhampton, which is in the Midlands. It's near Birmingham. Okay, the family of a man killed by the UK's youngest knife murderers said they are haunted by thoughts of his last moments and how scared he must have been. Shawn Seesahai, 19, was waiting with a friend on playing fields in Wolverhampton when he was killed by two boys, then aged 12, wielding a machete. The boys, who are now 13, were found guilty of murder after a 20-day trial in June and are due to be sentenced on Friday, which is today. So, as I said, the sentencing happened this morning. The prosecutor, Michelle Healy, QC, what does QC stand for? King's Counsel, I think. Anyway, told the court on Thursday that the boys were the youngest knife murderers and there was little precedent for the sentence they should receive. Well, the mandatory sentence for murder in the UK is life. Life. However, life does not mean life. No. The sentence that we call a whole life order, life in prison without the possibility of parole, is true life, right? You're in prison for life. You're in prison for the rest of your life. That rarely happens here in the UK. Rarely. It does happen. Lucy Letby, the nurse, who I'm still intending to do a big video on Lucy Letby, given that there is an increasing interest in her case. She got an whole life order. There's been a few. There's been a few, like the Yorkshire Ripper got a whole life order. The Mills murderers, actually, did they get a whole life order? I don't think they did, because Myra Hindley kept applying for parole. But the lowest mandatory sentence that a judge can issue for murder by an adult, so an adult who commits murder, is 15 years. So the judge has to give at least 15 years for murder, which is insane in itself. Many judges give more. For example, Tommy Cashman, who murdered a 9-year-old Olivia Pratt-Corbell, he got 42 years, a minimum of 42 years before he could apply for parole. So he would be in his 70s before he can even apply for parole. So to me, that's pretty much your whole life, right? If you're in your 70s, by the time you leave prison, to me, that's a decent sentence. Rose West, did she get a whole life order? Did the boys share the machete? They don't know who actually wielded the killer blow. So they both got done. They both got done. There's a theory that Myra Hindley was actually paroled secretly and they lied about her death. Really? Really? I didn't know that. I didn't know that. I know that Ian Brady never got out. Because I know some of the psychologists who work with Ian Brady at Ashworth Hospital, where he was on hunger strike and all sorts of things. Yeah, it's King's Council now, Queen's Council. The Queen died, so it's King's Council. Do the UK youth play those awful shooter video games? Think they make youth violent? Yeah, video games are very popular here in the UK. Honestly, I don't think they make people violent. I mean, look, it's debatable. I used to teach stuff on video game violence. I used to know the literature really well on it. I don't anymore, but TV violence, video game violence. Well, it's never made me violent. The only game I've really been interested in, I used to play Tekken when the PS first came out, when PlayStation first came out. Tekken's a fighting game. I was good at Tekken. And then the only other game I've really played is, what's it called? San Andreas. What's that called? I can't remember the actual name, but it was the San Andreas version. And I couldn't do any of the missions. I couldn't even get through the first mission. So I just used to go around shooting the police. And I've never felt the need to go shooting the police in real life. GTA, thank you so much. Grand Theft Auto, yeah. So I used to drive around listening to country music and then shoot the police and try to get over to the second island that you're not allowed until you've done so many missions. I never made it to the second island. I nearly did often. I used to swim across to the second island and there was like helicopters chasing me and stuff. I think if you've already got a propensity for violence, then it can create an issue. But for the majority of people who are well adjusted, I don't think it maps over. Myra Hindley would be so recognizable. Someone would have found out where she was. Yeah, I think so. She did look very different, though. If you saw like the photos of Myra in her later life, she looked very different than the young woman who got done. She looked very different. So maybe you could get away with it. Go and live somewhere remote. You could get away with it, I think. But anyway, who's in the house? We got Naomi Rose, Mike, Terry, Kimberly, CW building a chicken coop. CW, you're braver than me. I'm not very handy either. If I can't use brute force, then it ain't going to work for me. Donna with love, hello. Karen, we've already said hello to Purple AJ. We've got We Are Dust, Angie. We've got Sharon, Leah, Kathy. We got a few people in. All right, good stuff. Okay, so Shawn Seesahai. Let's read this first of all. All right, so the victim was from Anguilla. I don't know how to say that. A British overseas territory in the Caribbean, and had recently travelled to the UK for medical treatment. In a statement read to the court by Dorothea Hodge, the UK representative for Anguilla, His family said they were struggling in so many ways after his murder, which appears to have been for no reason at all. We are devastated as a family, totally heartbroken and confused. None of us have had an unbroken night's sleep since Shawn was taken from us. Every time I close my eyes, all I can think about are what his last moments were and how scared he must have been. It continually breaks my heart. The family said they've also suffered financially, spending their life savings to have Shawn's body repatriated and taken out a loan to attend the murder trial in the UK. So this is the devastation that this moment of sheer brutality has had on Shawn's entire family. I want you to bear that in mind. The impact on us as a family is devastating. It's hard to believe that we will ever come to terms with what has happened. Shawn was a very loving child to us. He was very helpful and hardworking. He loved to help out with Dad in construction and loved to help with the household chores. He was a humble person and his personality was unique. The trial heard how the two boys, whose identities are protected by a court order due to their age, which I find insane. They've been convicted. Why can we not know their names? They've been convicted. Why can we not know their names? Like the Brianna Jai, the murder of Brianna Jai, the judge said once they've been convicted, they were two minors, she released their names. Jamie Bulger's killers' names were released once they were convicted. I think this judge needs to give her head a wobble. All right, so they were roaming the streets on the 13th of November last year when they got into a confrontation with Shawn and his friend over a park bench. His friend fled, but Shawn stumbled to the floor, and in the ensuing attack, he was punched, kicked, stamped, and chopped at with the weapon, which is a machete. One stab wound puncturing his heart and lungs. There was conflicting evidence over which of the boys had inflicted the fatal injury with the machete, although one admitting to owning the 42.5 centimetre long blade and was known to have regularly carried a weapon. Why is a 12-year-old walking the streets with a machete? I want to know the answer to that. Why is it acceptable for a 12-year-old to walk about the streets with a machete? Where are his parents? The court heard that this boy, deemed by the prosecution to be the initial aggressor in the attack, has been groomed, exploited, and trafficked by older youths and young men in the wider community who encouraged him towards the possession of knives. All right, okay, so he's 12-year-old, very impressionable, trying to live up to, older young men's expectations. Don't know what they mean by trafficked. I don't know in this context. Don't know what they mean by that. Has he been exploited sexually? What's been going on here? And once again, where are his parents? Because it may be that he was carrying the machete for protection. So I'd like to know this boy's history. I'd like to know what happened to this boy previous. But a 12-year-old, you're a baby at 12. Rachel Brand, Cassie, representing this youth, said he was being exploited by those older than him. One only had to think of the places he was found sometimes late at night with no explanation how he got there. The court heard he had experienced significant trauma in his life, was at a high risk of child criminal exploitation, and came from a deprived home with family members who had offended. All right, so they're not gonna step in, are they? So why didn't the state step in? Why didn't the state step in? I mean, yeah, he's 12, he's vulnerable. If they knew that he was being exploited if it was known. Well, like, did his school? What about the school? Did they not intervene? Like, if they knew that he was being deprived, presumably, you know, I don't know whether there would have been drugs involved, but where's the state? Where's the state? He was under the care of his grandmother, who had brought his behaviour to the attention of social services on a number of occasions, but only had intermittent contact with support workers. So once again, social services, so CPS, has failed this child who's gone on to commit a brutal murder. Now, presumably, the grandmother maybe stepped in, has brought the case to social workers, hoping for help, presumably, and has not been given such help. So that's a problem. His co-defendant had also experienced significant disruption in his home life, the court heard, but there's no evidence he carried a knife. After their conviction, Mrs. Justice Tipples, who we're going to see in a minute, ruled the defendants could not be identified by the media because of concerns for their welfare. All right. So that's the sob story. I'm not saying that isn't true, right? I could well believe that, you know, kids being brought up in deprived homes where, you know, everyone's a criminal, where social services have just turned their back and just let things happen. And this has now resulted in a brutal murder. And this young man here, Shawn, has lost his life because of it. Broken system, yes. Broken system. Well, even more broken, because we're going to listen to this. So I'm playing this from Sky News, and this is the sentencing. I'm not going to interrupt it, even if even if I want to show it at the screen. We can talk about it after. All right, so I'm going to play it here. Cameras in court, please stand by.
Before I start, it must of course be remembered that the defence in this case are children, and pursuant to orders made under Section 45 of the Youth Justice and Criminal Evidence Act 1999, the publication of anything likely to lead members of the public to identify either defendant concerned in these proceedings is prohibited. But those orders apply to all the rest of today's hearing, as well as what I said earlier on. Shawn Seesahai had a unique personality, was a humble person who loved to help others and cared deeply about his family. His mother has described him as a brave soul who was generous and compassionate. He was born and brought up in Anguilla, and that is where his family live. Shawn came to the UK for treatment for his eyesight and to improve his education. He was adored and loved by his family, and as a young man aged 19, his whole future was ahead of him. On the 13th of November last year, he was murdered by the two defendants, who acted together and killed him with a machete in a park in Wolverhampton. The defendants are children who were aged 12 in November last year and were still aged 12 when they were convicted by a jury at Nottingham Crown Court in June. They are now aged 13. The first defendant pleaded guilty before trial to the possession of the machete in a public place, and the second defendant was convicted of this separate offence by the jury. Today, I have to sentence the defendants for the murder of Shawn Seesahai. I also have to sentence them for the possession of a knife in a public place although that offence adds nothing to the offence of murder in this case. Murder is the most serious criminal offence, and the sentence is fixed by law. There is only one sentence I can give the defendants in this case, and because of their age, it is called detention during His Majesty's pleasure. This is a custodial sentence, which means that the defendants will remain in the secure accommodation where they've each been living since they were arrested. I'm required to determine the shortest length of time each defendant must stay in custody before they can be considered for release by the parole board. This is called the minimum term. It is then for the parole board to decide when a defendant can leave custody, and their decision depends on a defendant's behaviour in custody and whether it's safe for that person to leave custody. The law requires all judges sentencing children or young people, however serious the offence, to have regard to the principal aim of the youth justice system, which is to prevent the offending by children and young people, and the welfare of the child or young person. The Court of Appeal has made it clear that sentencing children and young people requires an entirely different approach than that which the courts routinely apply to adult offenders. One aspect of that is that in communicating sentences to children in a case like this, the court can break the sentencing remarks down into stages. That is what I have done in this case. The first stage is for the judge to inform the child of the sentence and tell them the reason for that sentence in brief and simplified language which they can easily understand. The second stage is for the judge to provide sentencing remarks so that everyone can understand the judge's reasons and be sure that all relevant legal and factual considerations have been taken into account. These remarks are that second stage of the process. I dealt with the first stage earlier this morning. The facts of this case are horrific and shocking and can be explained very shortly. The first defendant bought a machete from a friend in October last year for £40. He kept it under his bed. On the 13th of November, he came home from school, got changed out of his school uniform into a tracksuit, picked up the knife, left home, and met up with the second defendant, a friend from school. They then met up with other friends, and by early evening, they headed to Snail Field, where they were soon after 8 p.m. Shawn Seesahai was visiting Wolverhampton with a friend, and earlier in the evening, they were sitting on a bench in Snail Field, chatting about their plans for Christmas. About 8:15 p.m., Shawn and his friend left the bench and walked away from it past the defendants. The defendants were then at the bench. Shawn returned after a few minutes, spoke to the defendants and asked them to move. Moments later, he was dead. The defendants jointly attacked Shawn and killed him. The defendants immediately left the field together, the first defendant picking up the machete, which he returned home with, cleaned it with bleach and put it back under his bed. The defendants were arrested the next day. Shawn was killed by a stab wound to his back caused by a machete, which almost went through his entire body, was 23 centimetres deep, and penetrated his lungs and heart. There were also injuries to Shawn's head, arm and thigh. The cut to the head was caused with such force it went through Shawn's scalp and into his skull, resulting in a bone flap. I'm sure from the nature of these injuries that the defendants intended to kill Shawn. They acted together to do so, although I cannot be sure which one inflicted the fatal stab wound. It was an attack which happened on the spur of the moment and was not premeditated. I have explained that the only sentence I can pass on the defendants is detention during His Majesty's pleasure, and I have to set the minimum term that the defendants must serve in custody before they are considered for release. I must set the minimum term by reference to Schedule 21 of the Sentencing Code, as Parliament has enacted. This case falls within paragraphs 5A and 4 of the Code, which means that, as the defendants were 14 or under at the date of the offence, the starting point is 13 years. The starting point reflects the seriousness of the offence. I then have to approach the task of setting the minimum term by looking carefully at each defendant on an individual basis, both in terms of what they did, together with the information I have about them as people, their backgrounds and experiences. I am required to undertake this exercise by reference to the Sentencing Council guidelines, sentencing children and young people. This guideline identifies in detail the very many important considerations and factors that I am required to take into account. I also have to look at the list of aggravating and mitigating factors set out in Schedule 21. There is some aggravation because this was an attack by two people, but the relevant mitigating factors are the lack of premeditation and the age of the defendants, all of which I have taken into account. The barristers in this case have also assisted me with their written sentencing notes provided in advance of the hearing, together with their oral submissions at yesterday's court hearing. I now turn to each defendant. The first defendant was much closer to 12 in age than 13 at the date of these offences. The pre-sentence report for the first defendant has been prepared by the two social workers who were allocated to work with him from when he was remanded in youth detention accommodation in November 2023. The report is dated July 2024 and has been prepared in accordance with the National Standards for Youth Justice Services and relevant guidance. It is a detailed and comprehensive report in which the social workers have collated information in relation to the first defendant from all relevant sources, both in terms of documents and speaking to the relevant people, including the first defendant. I have read all of this report with care and taken all that it says into account. Part of the report deals with the assessment of the first defendant, including consideration of safety and welfare issues. This section in the report details the extensive involvement of children's services in the first defendant's life and the reasons for that. The report also explains, amongst other things, that the first defendant has been referred to mental health services and there have been instances of self-harm. He was diagnosed with ADHD in 2022. It is in this context and against this factual background that the report says this, and I quote, "Having spoken with the first defendant and consulted records held about him, we would assess that the first defendant seems to function at a lower level than his chronological age, both in terms of understanding and his emotional literacy. The first defendant is a child with extremely complex needs. He has experienced violence from within the home from an early age. It is clear he has experienced change, loss, and unpredictability, which must have an ongoing impact on his sense of identity and belonging. His experience of such developmental trauma is highly likely to have had a negative impact on his cognitive development, his ability to regulate his emotions in the moment, and to take informed decisions. He was made even more vulnerable through his ADHD diagnosis. The report then continues by saying that there is a professional consensus of opinion that the first defendant was being groomed and exploited, and that in the professional's view, his experiences in this respect contributed indirectly towards his participation in Shawn's murder. Another part of the report assesses the risk to the community, including the likelihood of reoffending and risk of serious harm to others. This explains that at the time of the offences, there were significant concerns about, amongst other things, the first defendant's access to knives, exploitation, and how easily he was influenced, which meant that the likelihood of offending and serious harm were very high. The authors of the report note that this has to be seen in the context of the first defendant's very many adverse childhood experiences. He is now in a safe place where people will help him, and he has undertaken meaningful work, which is helping him to make positive changes to his thoughts and behaviours. They are hopeful that his secure placement will result in further reducing his risks in the future. The report also explains that the first defendant has spoken about what he did, that he said it is not fair that someone lost their life, and he feels sad about it. He said he feels bad that he took the knife out with him, and he wished things had gone differently. There is also a pre-sentence report dated the 11th of September of this year, which updates the court. The first defendant continues to do well at the secure unit, and the conclusions set out in the original report remain the same. I have also been provided with and have read the report of a consultant clinical psychologist in relation to the first defendant. That report also explains that the first defendant is particularly vulnerable and immature, identifies further diagnosed disorders beyond ADHD, and explains that his verbal reasoning abilities are equivalent to those of a 10-year-old. The report also records the considerable progress that the first defendant has made, where he is now living. Finally, I have a letter from the National Counter-Trafficking Centre dated July 2024, which explains that the first defendant was a victim of child criminal exploitation, and it is accepted he is a victim of modern slavery. The starting point of 13 years needs to be adjusted downwards because the first defendant's chronological age was that he'd relatively recently turned 12 at the date of the offence. I then have to take into account that at the time of the offence, his emotional maturity and developmental age were less than that. He has been adversely affected by multiple traumas throughout his childhood, for which he is and cannot be responsible. These are all factors which diminish the culpability of the first defendant. The first defendant always accepted he bought the knife and took it to the field, and he's shown some insight into the harm he has caused. But I agree with the authors of the pre-sentence report that he does not at this stage have the maturity to fully appreciate the consequences of his actions. On top of that, he's making progress with his behaviour and education in the stable and settled environment where he is living, and that should continue to progress. The first defendant did not have any previous convictions, but he was known to the police and had been carrying knives. But that has to be considered in the context that he was the victim of trafficking and extremely vulnerable. I have taken into account everything I know about the first defendant and what he did, and in my judgment, the minimum time he should spend in custody is 8 years, 6 months. From that must be deducted the 315 days that he's already spent in custody. The first defendant will remain on license for the rest of his life. This means that there are conditions that will be decided when the parole board decide it's appropriate for him to leave custody, and he will have to follow those conditions for the rest of his life. And if he does not do so, then he may have to go back to custody. I now turn to the second defendant. The second defendant was much closer to 12 in age than 13 at the date of these offences. The pre-sentence report for the second defendant has been prepared by the 2 social workers who were allocated to work with him from when he was remanded in a secure unit in November last year. It is dated July 2024 and is a detailed and comprehensive report, which has also gathered information about the second defendant from all relevant sources, both in terms of documents and speaking to the relevant people, including the second defendant. I have read all this report with care and taken all that it says into account. The report explains in detail the second defendant's background and upbringing, the upheaval caused to his childhood by moves in the location of his family's home, some of which was spent in a refuge, and the disruption this caused to his childhood. The second defendant has a supportive and loving relationship with his parents and his brother. He was not known to social services or the police at the time of the offences. The report explains that the second defendant expressed that he feels remorse for what happened, and he feels sorry for Shawn's family and understands that they are suffering greatly having lost their son. It is possible that the second defendant has dyslexia, but that's not yet been confirmed. In terms of risk, at the date of the report, the second defendant was assessed as a medium risk of reoffending and a high risk of serious harm to others. The report then says that it's important that he continues to engage with the support and interventions where he's living, as that will give him something positive for his long-term future. The authors of the report accept the serious nature of the offences and what the second defendant has done, but comment very positively on his behaviour since he's been on remand, his motivation to do well and to achieve qualifications. The report also makes clear that whilst he is physically mature for his age, he is still young, and it will take time for him to mature emotionally and developmentally in an environment where he feels safe. I have an updated pre-sentence report dated the 5th of September, which confirms the conclusions in the earlier report. This further report also provides more information as to how well he is doing where he is living, and that he continues to behave in a positive and mature manner. He is on graduate level and has received recently an award to commend him for what he has achieved where he is living. The starting point of 13 years needs to be adjusted downwards because the second defendant's chronological age was that he'd relatively recently turned 12 at the date of the offence. His emotional maturity and development age was not below his chronological age. He does not have any mental health problems but may have dyslexia. I then have to take into account that he's now showing maturity beyond his years. He is responding very well in custody. He was of good character and has shown remorse for what has happened. I have taken into account everything I know about the second defendant and what he did, and in my judgment, the minimum time he should spend in custody is 8 years, 6 months. From that must be deducted the 315 days that he has already spent in custody. I appreciate that this is the very same as for the first defendant, but having applied the guideline, the factors that have led me there are different. But when I have considered and balanced the individual features of each defendant, that is the clear conclusion that I have reached for each of them. The second defendant will also remain on license for the rest of his life. This means that there will be conditions decided when he leaves custody, which he will have to follow for the rest of his life. If he breaks those conditions, then he may have to return to custody. I order no separate penalty for the first defendant on count 2, possession of a bladed article in a public place. I order no separate penalty for the second defendant on count 2. I order forfeiture and destruction of the machete. I make no order for costs and no order for compensation. The victim surcharge applies. Finally, I would like to extend the court's condolences to Shawn Seesahai's family and to thank them for the dignified way in which they have conducted themselves during this trial. I'd also like to thank the police, all counsel, the intermediaries, and all the court staff involved. That concludes these sentencing remarks.
Okay. Okay. Unbelievable. Unbelievable. This young man here is Shawn Seesahai, 19 years old, his whole life ahead of him. Brutally murdered. This judge seems to think that carrying a machete, like just, going from school, changing from your school uniform into a tracksuit, and then going out, sitting in a park with a machete, and then brutally kicking, punching, and stabbing a young man to death has no premeditation whatsoever. All right, okay. All right. Well, my definition of premeditation is obviously different from that of Judge Tipples or whatever her name is. 8.5 years. 8.5 years with no additional time for the carrying around of a machete. Even though carrying a machete around is illegal in itself. Just carrying a machete around is illegal in itself. Carrying any blade, you can look this up yourself, carrying any blade that is longer than 3 inches is illegal. Like in public. There are certain circumstances where you can carry blades longer than 3 inches. Like I've got a sword and I can carry my sword around as long as it's in its scabbard and as long as I'm going from A to B. All right. But just wandering around with a machete, no. Yeah, you can get 2 years for saying hurty words on the internet. Yeah. No way. All right. This is insane. And she said, right, the minimum term for an adult, so somebody 18 years and older for murder, the minimum term is 15 years. And Judge Tipples said that the minimum age for murder for somebody, committing murder who's 14 years and younger is 13 years. That's the starting point, 13 years. But she edged it down and edged it down and edged it down to 8.5 years because of the sob story that has been written in these social worker reports. Note that defendant one, so the guy who bought the machete in the first place, oh, don't you worry. You've preempted me. Don't you worry. Carly Gregg is on my mind. Carly Gregg, I'm going to talk about in a second. Defendant one. All right. So bad life, being exploited, living with his grandmother. She's tried to get him help. So he's troubled. He's a troubled kid. All right. Mental age of 10. Well, Judge Stipples might be aware that the age of criminal responsibility in the UK is 10. So even if a 12-year-old commits a serious offence like murder, but has a mental age of 10 years old, under UK law, that child is still criminally responsible. All right, so yeah, they've gone through court, they've been on remand, they're in a juvie, some kind of, youth detention place, probably playing Xbox and probably having pizza every night and all of that stuff, while Shawn Seesahai is, his family have had to get into debt to just repatriate him, just to take his body back to his home. They've had to spend all their life savings and get into debt just to do it, just to repatriate the young man so that they can bury him in a place where they can visit him, presumably. So defendant one, oh no, had ADHD. Well, that surely needs to be an excuse. Someone with ADHD, well, can't cope with that in your life. And then what's even worse, what I found even more astounding, was defendant two. So we can have a certain amount of sympathy for defendant one, that he's had a troubled life, he's experienced trauma, he's been exploited mentally, cognitively, he's not of his chronological age. All right, we can have certain sympathy, no excuses, but we can have a certain sympathy for that. And we can say, well, social services surely should have some culpability here, that they should have intervened. They knew that this young man's life was a bad one. Where was the school and where were social services? So we can make all of those arguments. But defendant two, none such arguments exist, because defendant two came from a good family. Defendant two had no hardship in his life. Oh yeah, I've forgotten. He may have dyslexia. So, he might struggle with spelling. He might struggle maybe to, write words without getting letters mixed up. All right, yeah, okay. So dyslexia is the worst that defendant two experienced is in entire life. And yet he got the same sentence as defendant one. And, insane. So by the age of 19, so these guys have been on remand, so they've been in youth detention for the last almost a year. So she's taken off 300 and whatever days, because they've already served those, right? That's fine. So basically, by the time they turn 20, they'll be released. So they'll be released on license. And well, if the parole board considers them dangerous, then they won't be released. Right. So it's 8.5 years is the minimum term they have to serve in custody. And then they'll be eligible for parole. The parole board will look at them and say, oh, no, you've got ADHD and you've done so well with your education. And, oh, no, you've got dyslexia and you've done so well with your education. And they'll get released. Mark my words, they'll get released on license, which means that if they get into trouble in the future, they'll go back to jail. They won't collect £200. They won't pass go. They'll go back to jail. So what? So what? So by the time they reach the age that Shawn Seesahai was when he died, these two lowlifes, these two young thugs, will be getting ready to apply for parole. Let's put that into perspective. So Shawn Seesahai, at the age of 19, is dead forever. By the age of 19, these two young thugs will be getting ready for release. They will be working with psychologists and working with social workers who buy everything. Don't get me started. I can't even start on how much nonsense psychology is with rehabilitation of offenders. Don't get me started. Do not get me started. So they'll buy all the sob stories and they'll say, oh yeah, you've done so well, you've got work experience, you've got qualifications, you know, you've kept your noses clean, there you go, you can go. And they'll open the door and they can live the rest of their life. They've got their entire adult life to spend. Hopefully, they've learned their lesson. Hopefully, they don't go buying machetes, and hopefully they don't go and kill anyone else. But even so, where's the punishment? Where's the punishment? All right, they're going to spend their teenage years in custody, but it'll be cushy. Won't be in a prison. It'll be in youth detention. They'll be playing video games. They'll be going to school. They'll probably get a better education than defendant one. Certainly will get a better education than perhaps he would have done outside. And perhaps he's getting psychological support for his trauma. Hopefully. All right, I don't mind that. That's fine. But they have their entire adult lives to lead, while Shawn Seesahai is dead forever. No punishment period. No, with no punishment. No punishment here. Right, I want to refer you to this case. The case of CHORLEY Gregg. Now, some of you will know this case because CHORLEY Gregg has recently gone to trial. I've watched her trial. It's only a week long. Like, the trial is very short. CHORLEY Gregg was 14. This is CHORLEY Gregg. She was 14. So under UK law, 14 years and under, CHORLEY Gregg, if she was, in the UK, her starting point for sentence would be 13 years for murder. Right? Her starting point, not the minimum mandatory, because if you're an adult, 18 and over, the minimum mandatory is 15 years for murder, which is insane in itself. But most judges count upwards. But because CHORLEY was 14, so 14 years and younger, if she was in the UK, her starting point for sentence will be 13 years. And then they can count up if there's loads of aggravating factors, or they can count down if there's mitigating factors, like, I don't know, she might have dyslexia or something. All right. Instead, CHORLEY Gregg, this is Mississippi, sentencing took place. I mean, this was the most efficient court I've ever seen. Did you watch it? I watched it. I was very impressed by the judge. So quick, right? So the jury came back very quickly, like within 2 hours. They came very quickly, and they found her guilty. And then they had to go back. This Mississippi law. They had to go back to determine the penalty as to whether Carly Gregg was to be given life or given life without parole. So they came back and said they gave her life. Now, it's unclear to me whether Carly Gregg has been given life without parole. It's a bit unclear to me. But it's seemingly that Carly Gregg will spend the rest of her life in prison. What did she do? Well, she shot her mother. This is her mother. Carly Gregg shot her mother. And she admitted it. Like there was no attempt to get out of it. You know, she said, yeah, I did it. Because she's on camera. She's right here. Like the camera inside the house. So didn't actually see her shooting because it happened in a bedroom. But you saw her like walking about with the gun. You saw her talking to the dogs. And she texted her stepdad to get him to come home because she wanted to kill him as well. Do I think the stepdad was truthful and sincere? I thought the stepdad perhaps had bought into some kind of sob story. That's what the impression I got. So if you don't know the case, right? So Carly Gregg, she admitted it. However, her defense said she was not guilty by reason of insanity. And she had bipolar. There were some issues with her life. I'll read this article. It might help us here. Okay. Because they said she had bipolar, and she recently changed her medication. She was having some kind of psychotic episode. That's what they argued. And one of the defense witnesses, I thought, spoke very, very well. I thought he was very believable. I thought that maybe the jury would buy it. But it's the surveillance video. It's the surveillance video that was her downfall, because you could clearly see that she was waiting and she was planning, and also the text messages that she sent her friend. And she texted her stepdad from her mother's phone as if like her mother was writing it to get him to come home so she could shoot him as well. And she did shoot him, but it was only a graze. So she got done for murder of her mother and attempted murder of her stepdad. Now, her stepdad spoke on her defense and said that, she was mentally ill. It was like, she wasn't herself and all of this stuff. All right. So he bought in. And look, was she insane? No. I think she was mentally ill. I thought what the defense witness, the clinical psychologist, said was probably true. That, she probably was unstable because she had some kind of mental illness, whether it be bipolar or something else. And a change of medication made her even more unstable. And I thought, yeah, that's probably true. However, insanity is not being mentally ill. Insanity is that you are so out of reality that you literally do not know right from wrong. That's true legal insanity. We had this conversation when we did Letitia Stout, when Letitia Stout was pleading insanity. We had all of these conversations then. Go back and check my live streams on them. Because whatever mental illness Letitia Stout had, she was still saying, yeah, insane defense can't be a get out of jail free card. No. And it isn't. Somebody who truly does not know right from wrong, who commits murder in the throes of psychosis, literally, you know, they're out of their mind and they don't know right from wrong. They don't go free. They get housed in a secure, you know, secure hospital, secure unit, and they may or may not be released. They probably will be eventually if their sanity can be restored. But this is what Carly Gregg did. Have you ever seen a dead body? It's the chilling question then 14-year-old Carly Gregg asked her friend after she shot and killed her mother, high school teacher Ashley Smiley, inside their Mississippi home earlier this year. Carly told the friend to come over, claiming there was an emergency, before revealing the horrifying situation, telling the friend, "My mom is in there." During the week-long murder trial, jurors heard how the teenager shot Smiley, 40, to death with the shooter on March 19th of this year. So very quick turnaround, this trial, when they got home from Carly's school. Prosecutors told the court that the shooting was carried out because Smiley had discovered her daughter's secret life. She was smoking marijuana. So Carly was this exceptional student, very, very intelligent, and perhaps somewhat arrogant about her intelligence. Like she you know, she lived this somewhat charmed life with her mother and her stepdad. Now, her biological father did have problems. Her biological father was a drug user. So the defense used that, you know, Carly's early life with her biological father wasn't so great. However, the life that she had with her mother and her stepdad was one of fine. She was fine. She was very intelligent. All right. But she was vaping, she was taking marijuana, and her mother found out about it. So in order to stop her mother shouting at her or whatever, she shot her dead, and meant to do it. She planned it. She knew where the gun was. She went and got the gun. She was walking around with the gun behind her back. And then she texted her stepdad, as I said, from her mother's phone to get him home. And then she shot him, but it was only a graze. And then you saw the surveillance camera outside. You saw her running away. So she absolutely knew right from wrong. She knew to conceal the weapon. She was texting her friends, knew that the body was dead, knew that her stepdad would come home when, you know, some bogus text was sent, and she ran away. So she absolutely knew right from wrong. Yeah, the devil's lettuce. Yeah, smoking marijuana. So, I don't know. So, Carly was painted as a dangerous killer who had burner phones, hidden vape pens containing marijuana, and a history of cheating at school and self-harm. Cheating in a test that she didn't need to cheat in. Carly then lured her stepdad, Heath Smiley, home by texting him, pretending to be her mother, writing, "When will you be home, honey?" When Heath arrived at the house, Carly shot him in the shoulder before he overpowered her, and she was arrested a short time later. The teen's defense argued she was experiencing significant mental health issues, and that while she was having a state of psychosis and an episode of acute stress, she lost herself in what was the perfect storm. Okay, a deadly secret. All right, what's the point of me bringing up Carly, sorry, not Kylie. Well, the judge in that case said, look, you know, the jury didn't buy the story, didn't buy it, you know, the one of insanity, and said, no, you know, the judge said, no, this was premeditated. She knew what she was doing. She shot her mother in cold blood, and then she tried to kill her stepdad, but her stepdad overpowered her, and he's now on her side. He now recognizes that she does have mental illness. However, that does not constitute insanity. So the point of comparing Carly Gregg's case with the case of the two unnamed convicted killers in Shawn Seesahai's case is that they're virtually identical in age. Like Carly was 14, the two boys were 12. Similar offence in a way, you know, brutal. In Carly's case, it was, you know, a gun that was in the home. But over a situation like next to nothing, like, yeah, she was having a tantrum. She was having a tantrum about her mother searching her room. So she got the gun, hid it behind her back, and then went in the room and shot her. And she will spend the rest of her life behind bars. Is she rehabilitatable? I think so. I think I'm uncomfortable with someone as young as 14 in, you know, someone who's very intelligent, who clearly does have some issues, but, you know, they're treatable issues, spending literally the entire life behind bars. I do have that. Makes me uncomfortable. I think somebody as young as 14 under those circumstances, yes, it's horrific. It's absolutely horrific what she did, but no possibility of parole. Seems like, you know, you're 14. It's a long time. It's a long time. So that makes me uncomfortable. However, 8.5 years. 8.5 years for the killers of 19-year-old Shawn Seesahai. Which is worse? I mean, even though I am uncomfortable with a 14-year-old spending literally the rest of their life behind bars with no possibility of parole, I can't get behind what this judge has done in Shawn Seesahai's case. 8.5 years. 8.5 years before they are eligible for parole. You could at least say 20 years. I'd be happy with 20 years for both Carly and these two guys here, these two 12-year-olds. 20 years or 25 years before you're eligible for parole. I'd be comfortable with that. Because they're very similar. They're similar crimes. Like, one's a gun, but in Shawn's case, a machete, carrying a 12-year-old boy walking around Wolverhampton with a machete is terrifying. Terrifying. Two different countries, though. But I know it's two different countries with very different sentencing structures. Like in the UK, we have very few whole life orders granted for murder. But which is worse? Sending a 14-year-old to prison for life with no possibility of parole, or sending two 12-year-olds to youth offending where they'll be playing video games, where they can go to school, where they can do everything that a teenager could do apart from going about on the streets carrying machetes. They can't do that. But they're going to be out. They're going to be out by the time they are 20. They're going to be out by the time they are 20. That cannot be right, surely. It's a lot in between, yeah. 8.5 years and your whole life in prison. The comparison for almost similar crimes, you know, a teenage tantrum because her mother found out she was vaping and wanted to, like, search her room and took her phone off her and whatever, so shot her. And then in Shawn's case, it was an argument over a park bench that sparked it. children are children, no matter in the world where they live. Yeah, absolutely. I don't think the fact that it's a different country is relevant. Shouldn't we be looking at offending children in the same way? Her crime was cold-blooded. The boy's crime was an avoidable altercation. Yeah, but Carly's crime was also an avoidable altercation. The mother wanted to find out what on earth Carly had been up to. I don't see. I disagree with Judge Tipples saying that the murder of Shawn wasn't premeditated. I think there has to be a degree of premeditation when you argue with somebody over a park bench and then you punch them, kick them, and stab them to the point where there was a 23 centimeter wound, like almost through his entire body, punctured his lungs and his heart. So they stabbed him in the back. He was walking away. They stabbed him in the back. It went through his lungs into his heart. Now, the amount of force you would have to use, even a machete, that you would have to use to go through somebody's, like, unbelievable. And then they slashed his head into his skull. The amount of force that you'd have to use on his head. Surely that's premeditation. That is just as cold-blooded, in my opinion. That is just as cold-blooded as having a teenage tantrum because your mother is searching your room. Any CCTV of Shawn's case? Not that I know of, because it was in a park, but I don't know. I don't know whether there was CCTV. Presumably there would have been CCTV maybe of them running away, because they were arrested the day after, so... Carly's mother was not able to predict her daughter's level of mental disturbance. Professionals and authorities never listened to Carly's mother. Carly goes right to adult prison, yeah. Yeah. Shawn was the instigator. Shawn told them to get off the bench. So there would have been some kind of argument, presumably. But he was stabbed in the back. So he's already either down, like they punched him, kicked him. So he's either already down on the floor before they stabbed him in the back, or he's attempting to run away. So whatever altercation happened, surely you do not deserve that to happen to you. Yeah, he was either down on the ground or he was leaving. He was attempting to run away. But in Carly's case, you could argue the mother was the instigator. That, she angered Carly. She angered Carly. So, well, it's ridiculous. But these are very, very similar cases. Very similar. In my opinion, very similar cases. And we have an 8.5-year sentence. 8.5-year sentence. Even if Shawn like, I don't know, was arguing with them. So what? Who hasn't ever had an argument? You don't expect to be stabbed in the back with a machete and then have your scalp almost removed. No. Just like if you're a parent of a 14-year-old, you know, and you're attempting to discipline your child because maybe they've been vaping marijuana, and you get mad at them, you don't expect to be shot to death. Both cases very similar in that, yes, there's, you know, there's tension or something, an argument there, but in both cases that response was met with brutality. So this judge in the Shawn Seesahai case, this Judge Tipples, she's off her rocker, honestly. She's off her rocker. There's something wrong. So I think the state can appeal, I think. I don't know how it works now. Whether the state will appeal, saying it's too lenient a sentence, I don't know. Little kids egging each other on. Yeah, probably. It was 2-on-1, yeah. Yeah. Carly said shared voices. Look, I do think there was some mental illness there. I do think Carly was mentally ill. Whether it was bipolar, whether there was some kind of schizophrenic episode happening, but her behavior on the surveillance video, which they played in court, showed me that she was hiding that gun. She knew to go and get the gun, to hide the gun behind her back, text her friend, and then text her stepdad to get him home so that she could shoot him as well. So all of that shows a level, and then she ran away. So all of that shows me that she, in that moment, she knew right from wrong. So all of this, the story that the defense put together, it's very plausible that, yeah, she's mentally ill. However, it's not insanity. It's not legally insanity. Now, these two young thugs who murdered Shawn Seesahai, whatever problems might have been in defendant one's life, wasn't in defendant two's life. Defendant two had no problems in his home life. He had a normal childhood. Absolutely normal childhood. The worst he'd ever experienced is dyslexia. So he's bad at spelling. I know I'm being a little bit flippant. I know dyslexia is a little bit more than that, but still, you can't allow children to murder brutally and give them a sentence of 8.5 years. Look what happened with the murderers of little Jamie Bulger. Like, one of them has been done for child porn. He's in and out of prison because they were let out with virtually no sentence. Kids who commit murder, you know, unless there's some really, really disturbing mitigating factor, like, you know, that might involve a case similar to self-defense, the system has to take it seriously. And I don't believe that Judge Tipples has taken this murder seriously at all. And then on the other hand, in Mississippi, I think the law's a little bit too harsh. Sending like a 14-year-old sent to adult prison for life with no possibility of parole. That also makes me comfortable. So it's like two sides of the pond, two sides of the Atlantic, and two sentences that to me are the epitome of insanity. The sentences are insane. I'd like to see it, you know, maybe somewhere in the middle, like maybe 25 years, you know, puts them in the 30s. And then, you know, they're an adult, they've got their adult brain. You know, a psychologist would be better able to assess, you know, them as an adult, and then consider them, you know, with the possibility of parole. I don't know. It's maddening, absolutely maddening. But the state of the criminal justice system in the UK is just appalling. Appalling. Out of curiosity, what was their race? Do we know? We don't know. We don't know anything about them, apart from they were 12 at the time of the offence and they're 13 now. We don't know anything else at all. Lawyer Melanie Little interviewed her lawyer after the sentence. Oh, I saw that. I haven't watched it yet. I did see that, but I haven't watched it yet. I do plan to watch it though. We may possibly find out more when they reach 18. Well, if the names get released when they're 18, they'll get out of prison or juvie. They'll get out of juvie at the age of 20 and they'll get new identities and they could be living in your neighbourhood and you would have no idea. I have a problem with that. I have a problem with that. Melanie Little is a bleeding heart, though. I watch her, don't agree with her on much. I've watched Melanie Little in relation to Karen Reid, and I do agree with her assessment on the Karen Reid case. I don't think I've watched her on any other cases though. But I do agree with her on Karen Reid. Everyone at her channel thinks poor, insane Carly. I can't take it. Look, I do have some sympathy with Carly in that I do believe what the psychologist said was true, that she does have mental illness, that she was unstable, and maybe that was in part due to her medication change. But it doesn't justify murder. I'm sorry, it doesn't justify murder. And it doesn't fit the legal definition of insanity, which is a very simple one. Do you know right from wrong? If yes, then you're not insane legally. What does it mean to be let out on license? Is it like parole in the States? Yes. It basically means that you're on parole and you have to, the judge gives like a list of stuff. So on the terms of your license, there's a bunch of stuff that you've got to do or not do. And if you break it, then you go back to prison. So what it actually looks like for the individual is determined by the conditions of the license. So you might, I don't know, you might not be allowed to go to a certain place, or you might be, I don't know. So the like terms and conditions and stuff that you've got to sign and you've got to agree to. The Daily Mirror have published the police statement about the two 12-year-olds. Oh. Okay. P.S. It's on YouTube. Okay, let's have a look. Daily Mirror. Do you mean it's a video? I'll have a look on YouTube. Okay. Britain's youngest machete murderers jailed for life. So it's only 2 minutes. All right, let's listen. Let's listen in.
Quite yourself, first of all, Mum.
Hi, I am Chief Superintendent Kim Medill. I am the lead for serious youth violence for West Midlands Police. I am here today as West Midlands Police lead on serious youth violence, following the sentencing of 2 boys for the horrifying murder of Shawn Seesahai in Wolverhampton last November. His family are understandably heartbroken and mourning their beloved son, and our thoughts and sympathies will remain with them. Today's sentence can never make up for Shawn's life being taken, but we hope it can bring some comfort to all those who loved him. Shawn was only 19 when his life was taken at the hands of 2 boys, then aged just 12, who had armed themselves with a machete. That reality has had a huge impact on us all. It is both shocking and saddening. The impact of knife crime is devastating, no matter where you live in the country. This is an issue that affects us all. Much work has been done and we have had successes in some areas. However, this is clearly not enough. We are listening to families affected by knife crime and acting on their feedback to see what more we can do with partners to stop the devastation caused by knife crime. Our responsibility is to work together with partners to understand why children and young people think it is okay to carry weapons and take further action to stop this extremely dangerous behaviour. Our work will not stop, and any death or injury as a result of knife crime will never be acceptable. Thank you.
All right, okay. Do you know one thing that might deter 12-year-olds from thinking it's okay to go and stab people with machetes? Stricter sentencing. Because where's the deterrent? Surely criminal justice, part of the criminal justice system, should concern itself with deterrence. So an 8.5-year sentence in juvie is no deterrent. It doesn't spread a message to the population that knife crime, even that results in murder, is taken seriously. That if you're a kid, you can just go about stabbing people and you'll get literally a slap on the wrist. I bet the police are not happy. I mean, she was very diplomatic, but I can imagine that the police are not happy. Knife crime is a massive problem, particularly amongst young people. And the criminal justice system should really take on board how serious the situation is. And maybe stiffer sentences might, in some way, in some small way, offer a deterrent. Hold the parents accountable for allowing access to the weapon and not make... Yeah. Although, in defendant one's case, he wasn't living with his parents. He was living with his grandma, who tried to make the authorities aware... I don't know what Tilly's barking at. Who tried to make the authorities aware that there was a problem with him. So, and then defendant 2, he didn't possess the machete. But they didn't know who actually stabbed Shawn to death. So presumably defendant 2 was the kicker and the puncher, maybe not the stabber. But we don't know. The judge can't determine that. But defendant 1 pled guilty to the possession of the machete. But he didn't get any time for that. So did not get any time. No additional time for being the one who bought and kept the machete, who clearly knew that he'd done wrong because he went home and he washed the machete with bleach. Clearly knew right from wrong. Even if he had the mental age of a 10-year-old, he still had the foresight to take his machete home, wash it with bleach, and then hide it. So, in every which way, very similar to Carly Gregg. That, whatever problems she had, whatever mental problems she had the foresight to, to plan ahead. Smart for someone younger than his years. Absolutely. And yet, these two lowlifes are going to be out by the time they're 20 years old. You're not sure that harsh sentence is a deterrent. Australia seems soft on sentencing. Crime rates are lower than US. Yeah, I guess. But even if stiffer sentences are not huge deterrents, at least it sends the message to the public that these things are taken seriously. I can't see anybody who agree. Will anybody agree with an 8.5-year sentence for murder? Who saw the child and machete? I don't know. Probably one of the people he was hanging around with. Anyway, I'm going to go. I don't know what these dogs are barking at. Oi! No idea. All right, guys, I'm going to go. Crazy. Sounds like singing. Sounds like singing. Barking at Judge Tiddles. I think it's Tipples, not Tiddles. All right, I'm going to go. So thank you for joining me. I don't think this has been a hugely popular stream. However, it was one I wanted to talk about. Hopefully those on the replay crew will put some comments in the comment section that we can think about. It's a difficult one. It's a really difficult one. I am uncomfortable with someone like Carly Gregg getting life without the possibility of parole at the age of 14. But that's nothing to the discomfort that I feel about two thugs getting just 8.5 years for murder. Both cases, both extremes need to be, I don't know what the answer is. UK sentencing shockingly soft. It is shockingly soft. It's insane. I generally have more respect for the US system in the way that it's very strict. You know, that the judge isn't afraid of giving a life imprisonment without parole sentence. I just have an uncomfortable feeling about a 14-year-old being given a life without parole sentence. I do have that. I have that problem. That problem has been jingling about in my head since the day of the sentencing. But 8.5 years. 8.5 years. It's just crazy. I can't deal with it. And that's my country. Wolverhampton ain't that far away from me. It's about 80 miles, 90 miles. The system isn't perfect, but it's what we've got. It is what we've got. And we need an overhaul of sentences. We absolutely do. Totally agree. Totally agree. Totally. All right, guys. Thank you so much for joining me. Thank you once again to Purple AJ for donating memberships at the beginning of the live stream. I don't think anyone else donated. If someone did and I missed it whilst the sentencing was on, I do apologise. But thank you all. Thank you all for joining me. Thanks to the mods, as always. Enjoy the rest of your day. Yeah, Jamie Bulger was absolutely tragic. Tragic. All right, guys. Thank you, and see you soon.